At the Global South Network, we are deeply committed to promoting interdisciplinary and cross-regional conversation. Our mission has always been to create an inclusive platform where judges, academics, lawyers, and civil society actors from across the Global South and beyond can exchange ideas, share good practices, and learn. On behalf of the network, I am deeply honored to welcome our distinguished speaker, the Honourable Justice Peter Jamadar, Judge of the Caribbean Court of Justice, Vice President Programming of the Commonwealth Judicial Education Institute, and Chair of the Caribbean Association of Judicial Officers.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings? You came upon a series of lush islands with white sands, beaches that are caressed by warm turquoise blue water. But what did they do? They enjoyed the bliss and exploited the people and land for their own benefit. For locals and for commentators from the global south in the Caribbean, colonized, first of course the indigenous, the first peoples, and then imported forced labor in our region, their experience and reflections are that surf, sand, and sea can be tragic reminders of encounters with inhumane, cruel conquerors. For the first peoples of the Americas and the Caribbean, it is from over the sea and through the surf that these colonizers came in their boat, landed on the Caribbean's pristine sand beaches, turned their turquoise waters, their Caribbean seas red with the blood of so many innocents. However, not only were people and lands and resources colonized and exploited, and the point of today's talk is about fact and colonizations of our legal imagination has also been an enduring legacy of colonial history of Caribbean people. How can Caribbean peoples free ourselves from this mental slavery that has captured our legal imagination? Have we been developing a truly Caribbean jurisprudence? There can be no social jurisprudence separated from social context. And so social context is critical to this idea of a Caribbean jurisprudence.
Initiative.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provides a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is, I believe, the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
كانت جزء لا يتجزأ من الدولة العثمانية.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Quiero expresar mi sincero agradecimiento al Dr. Naumen Riad.
Dr. Naumen Riad, the founder and convener of the Global South Network. His visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas. Initiatives like today's dialogue allow us to compare jurisprudence, share best practices, and develop common principles. This has the potential to contribute to transnational standards in procedure and enhance administrative law globally.
I would like to point out that Dr. Riyad's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
We can rule when we want in the cases which are brought to us by citizens and residents. In the EU, this openness of mind is increased by the fact we apply, in some cases, same norms from the EU treaties or the EU directives or regulations.
On the one hand, I have spoken using the metaphor of cuisine in the Caribbean. They are distinct flavors. And if we are therefore to use that idea of differences as natural as breathing, how does a court comprised of the same judges adjudicating both in regional and in territorial hearings balance what can become what I call the imperial magisterium to universalize the law, which in a very real sense the JCPC did with all of its territories, right? When it administered the law as a judicial council. How does the CCJ not fall into that model? And I think the answer lies in self-awareness. So that I think it is unrealistic to suggest that, oh, that cannot or will not happen, because you are sitting in these two capacities, but you're also sitting as the apex board for several jurisdictions. And so there can always be this tendency to want to universalize for consistency, predictability, and regional integration, have similar approaches. But I think there is enough wiggle room to have commonality with nuance. And I think that's actually a human rights thing, because we need to regard and respect the individual sovereignty of each nation state. Yeah. So regrettably, for whoever posed that question, there's not a straightforward answer, yes or no. And so I think it is a self-awareness of the court, and through that self-awareness, having the skills and the capacity to nuance their judgments.